Legal challenges facing former President Donald Trump. Two different cases now require Trump's legal team to be in two separate states this week. This morning, we're also learning new information about search warrants executed on Trump's Twitter account back in January. The special counsel's office carried out that search in connection with the ongoing investigation over alleged interference in the 2020 elections. We have NBC News legal analyst Danny Cevallos here to give us some legal insight into these cases. But first, let's bring in NBC News legal contributor and MSNBC host Katie Phang from outside the courthouse in Fort Pierce, Florida, with the latest on this classified documents case. But Katie, first up, with that case in Florida, we know that Trump employees Walt Nauta and Carlos de Oliveira both had issues with getting legal representation for their arraignments and their past court appearances. So today, what can we expect with both men when they appear with their legal teams? And what more can you tell us about these new charges we've seen against Nauta?
Well, to your point, Walt Nauta had issues, and I put that in quotes, right, guys, because there were a couple of resets in court to allow him to find local counsel. And for people to understand, if you are barred, meaning you are licensed to practice in the Southern District of Florida, you are allowed to appear in court. Otherwise, even if you have a license to practice in another state, you cannot do so. So Walt Nauta had a couple of resets of his own arraignment, but he has to show up today at 10 a.m. Why? Because as we know, special counsel Jack Smith filed a superseding indictment, adding additional charges, including conspiracy to obstruct justice for Walt Nauta. Now, Carlos de Oliveira, as described in that superseding indictment, he's the new co-defendant in that particular charging document. He's the property manager at Mar-a-Lago. He had his own arraignment reset for this morning at 10 a.m. as well to be able to obtain local counsel. As of right now, as we have checked the docket, there is no notice of appearance that has been filed by local counsel on behalf of Carlos de Oliveira. So we're all going to be looking out to see who shows up on his behalf if someone shows up. Assuming arguendo there is local counsel, he will enter a plea. He being de Oliveira will enter a plea of not guilty, we suspect. And then the case will then continue. I just wanted to leave you guys with this. On August 25th is the next major hearing in this case. Judge Cannon is going to conduct a CIPA Section 3 hearing. That's the Classified Information Procedures Act. It's a hearing about a protective order. And we saw a flurry of activity yesterday where Donald Trump said that he wants to make Mar-a-Lago a SCIF, a secured facility to be able to look at those classified documents in this case.
Danny, let's bring you in to talk about the other federal investigation, the one into alleged interference with the 2020 election. There's a hearing set for tomorrow on that request for a protective order there. Earlier this week, we heard Trump say he would continue to talk about the case. So comments like that, could that have an impact on the Judge Chutkan's ruling in this one?
Well, it's already had an impact on the government, and the government is essentially going to argue, look, this is exactly what we were concerned about. But look, I actually don't think the parties are that far apart. Of course, they're disputing the contents of the protective order, but both sides seem to agree that a protective order is necessary, that it's appropriate, that the defendant cannot disclose categorically sensitive material like grand jury materials or sensitive personal information. What they're disputing, and I have to say on some level I understand the defense's argument here, is that they're concerned about agreeing to a protective order about what is sensitive before they've even seen what the documents are. And of course, the government is concerned about handing over those documents until they have an agreement about what is sensitive and what Trump can't post. Both sides, if they were being candid, the defense would say, look, everyone's worried about what Trump is going to say if he has access to these documents. And I should say also, they both seem to agree that Trump does not get to take the documents. They just get to show him, the defense team shows him the documents. So that's interesting, too, because almost by necessity, anything he posts about on Truth Social would be something about what he saw, not a document itself. Of course, if he posted a sensitive document, that's going to be huge trouble. I think really what the parties are disputing, I don't think they're going to reach agreement. I think the judge is just going to have to make a decision on this, what is sensitive and what the order actually covers.
We do want to point out Trump has pleaded not guilty in all these cases. Katie, now, though, we are hearing more about search warrants executed by the special counsel's office during its 2020 election interference probe. Officials looked into Trump's Twitter account for evidence of criminal offenses. That's according to a public court hearing record. Real quickly, what have we learned about this search warrant?
Yeah, so it's pretty fascinating. It's a search warrant, not a subpoena, meaning that a judge determined that there was probable cause that fruits of a crime would be found at a particular location, that location being Trump's Twitter account. There was back and forth litigation that was in secrecy. We didn't even know about it. There was an opinion written by a federal appellate court that was issued in July. It just became public, and it basically said, look, we, as in Twitter, were not allowed to be able to tell Donald Trump that there was the existence of the search warrant, but they were looking for documents that were related to that particular account. Clearly, whatever was turned over to Jack Smith, we don't know the value of it as evidence, but I guess that'll be left to be seen in future discovery.
All right, Katie.